I'm talking to you about substance and form in the UK. And my first statement is this. The UK has no general doctrine of substance over form in the tax system. I would like to stop there only so that I could talk to you for less time than Al Megji. But I don't think you'd actually let me get away with that. And of course, needless to say, nothing is quite as simple as what I've just said. Over the years, the same effect as a substance over form approach has been achieved in a number of different areas of taxation by other means, and we'll come on to some of those as I go through my presentation. But let me make one other bold statement, if nothing else to be a little bit controversial. The UK also does not have a sham doctrine in its tax system. Now, what do I mean by sham doctrine? This morning I've heard sort of various different definitions, but let me tell you what I mean by sham doctrine. I mean something that permits the courts or the tax authorities to treat purported legal relations between parties as something other than what the parties consider them to be purely because tax avoidance not evasion, dominates the relationship. That's not the same thing as saying we don't differentiate in the UK between looking at and looking through transactions, just as the Supreme Court re-endorsed, if you like, in the Vodafone decision here. We do, but the basis for doing so is contained firmly in principles of general law, for example, contractual legal analysis or trusts law. So, for example, if the parties choose to document a transaction as something which it clearly isn't, as a matter of contract, the courts will come to the conclusion that what the parties really intended was X, Y, and Z, and the tax treatment will follow. The point I'm trying to make is that there is no separate tax doctrine as such, which imports the sham doctrine in that situation. What does that mean in terms of what the UK's approach is? Well, first of all, that's why the way in which our approach has developed has been to scrutinize transactions, including steps in a transaction or series of transactions intended to operate together as a whole. We've made no real attempt in domestic tax legislation, I'm not talking about treaties, to look through legal entities like SPVs. We've tended to look at transactional capability, not the capacity in which legal entities act, unless, of course, they've been simply negligent or they've been somewhat reckless in the way they've done things. But that's not really what tax planning or tax avoidance is about, or at least it shouldn't be. The English and Scottish courts' approach to tax avoidance has sometimes come close to a substance over form approach, but it hasn't quite gone all the way. If you come to legislation, there are some areas where the doctrine has, for all practical purposes, been incorporated, but these are only specific areas and there's still no general statutory rule. As you've heard earlier on today, there is a new GAR coming in, which will come in from April next year. Now, unfortunately, the timing of this conference is not great from the UK GAR's viewpoint, because the final details of the GAR will be announced next week when the Finance Bill 2013 is published. So I can't tell you what it's going to look like finally, but I'll give you some key, a little bit of a key later on. But if, as it's anticipated, the new GAR is only intended at attacking the most egregious types of tax avoidance schemes, then it will not, I don't think, introduce a substance over form approach of general application. So if we now go on to look at how the courts have looked at this whole topic, and then I'll come on to legislation, and then I'll come on to some practical situations as we go along. The courts. Well, I've lost track of how many times the Duke of Westminster has already been mentioned. I was hoping I would be the first, but I'm clearly not.